in the court setting, there's a couple of terms you should understand, and so I want to introduce those to you. One is the concept of legal custody. So legal custody is that element of custody that involves the parent's right and obligation to participate in raising their own child. So this is stuff like medical decision making for a child who's not able to make medical decisions on their own because of age or other infirmities that they can't make those decisions for themselves. Educational decisions for your children, religion. Do your children get elective procedures or things done to their body, like piercings and tattoos before they're age 18 and can consent to that kind of stuff on their own? So all of those things fall under the umbrella of legal custody. So it is presumed, and in fact far more common, that people will share joint legal custody, and that means that they're obligated to participate, confer, discuss, share information, and come to a mutually agreeable decision about education, health, welfare, religion, upbringing, diet, etc. So if you are unable to do that, unable because you don't see eye to eye, if you say, I want my child to go to religious education, and the other says I absolutely do not, and the child must be in public school, there's no perhaps meeting in the middle ground on that. So if you're just polar opposites on all sorts of major topics, one of you believes in Western medicine, and the other believes in naturopathic or Eastern medications or medicine modalities. You're maybe not able to make mutual decisions. If one parent is unavailable because they're incarcerated, or they just refuse to communicate with the other, or they've disappeared, then one parent would have to necessarily have sole legal custody. So the court has basically two obvious options: joint legal custody or sole legal custody to one parent. The other side of the custody coin is, where do the kids spend their time? So this used to be referred to as physical custody. And if you go back a decade or more ago, somebody had physical custody and the other parent had visitation. We've moved away from that sort of construct and concept in more recent times because it's demeaning to say parents visit their children. Parents raise their children, right? So if you're in the custody game, you're raising your children. It's more common now to just say, how do we share parenting time? So parenting time can be shared equally. Parenting time can be shared completely unequally, but we refer to it as parenting time. And some parents need to have a schedule to be able to predict, to reduce conflict and points of decision making or possible disagreement with the other parent. So I've seen custody agreements and custody orders that spell out, like, every hour of every week and every special occasion and every holiday how the children's schedule will be handled and where the children will be and with whom. Other parents can say, we'll just work it out by mutual agreement, and we will adjust and be cooperative, and their parenting time agreements or orders are much more fluid and flexible and short, brief. So, families are unique, and these things are not one size fits all. So the beauty with not having a judge decide these things is you can tailor these things to as many variables and considerations as you wish. So I have parents sometimes who have very unusual work schedules, and they go to great lengths to come up with a custody arrangement or parenting time arrangement that accommodates the children's schedules, the children's activities, and both parents' work schedules to an extent and with the kind of precision and thoughtfulness that perhaps a judge would not take the time to do, or really understand what it's like to be living all of those schedules and managing all of those schedules when the judge determines a parenting schedule. So how's the court deciding any of this if the parents can't decide on their own and reach agreement? Well, in New York, we have what's called best interest of the child, and I believe every other state in the United States has something like that. They may have a variant on that concept. And you're probably thinking, what does best interest of the child mean? And that's a great question. And it's not one I can easily answer because it's very fact specific. What's best for your child may be very different than what's best for my child. And what's best for one child in a family may be very different from what's best for the other children in that family. Because every child is unique and every family is unique. So in family court, there are laws that govern family court, but most of the outcomes of family court cases are driven by the facts of the unique situation as presented to the court by the attorneys for the parties in the course of the proceedings. Now, that's an important concept to understand because in presenting the facts of your case, there are rules of evidence, and some things come into evidence and other things are not allowed in evidence in courtrooms. And the court is never going to have the time or the patience or the resources to hear everything you would wish the judge to know about you as a parent, about the other parent, and about your children's needs and aptitudes and special habits and so on and so forth. So a family court's getting a really quick snapshot of what you and your children are like, and they're making a decision that can last for a really long time. So courts do the very best that they can do with the information available, but you know your child better than anyone, and in my opinion, it's best to avoid letting the judge get to the point where unlimited information, necessarily limited information because the time and evidence restrictions in courtrooms, that they're going to be hamstrung a bit because they're never going to know what you would really, really, really want to know in great detail about your children.